First speaker is going to be Drew Jelinski. He is an assistant general counsel with the Wisconsin Department of Transportation. He primarily handles legal issues arising from highway projects such as right-of-way acquisition, contracts, environmental documentation, utility accommodation, and highway planning. He has provided the department with legal assistance on a number of major projects throughout the state, including recently completed St. Croix crossing in Stillwater, Minnesota, the US 41441 Interstate Improvement in Green Bay, Wisconsin, and the Foxconn development in southeast Wisconsin. Mr. Jelinski has been with Wisconsin DOT since 2013. He's been a practicing attorney for 8 years, and his legal background includes time as a litigator handling construction defect claims, business disputes, property damage claims, and real estate issues. Welcome, Drew.
Good afternoon, everybody. Today I've been tasked with the fun and interesting topic of handling unusual access management situations. And the way that I came up with the way that I wanted to attack this presentation was just try to run through when I get a call or I get a question from some of my folks at WisDOT, what do I run through in my head when I'm analyzing these situations, when I get these questions? And I just tried to put that in this presentation, and hopefully this is a helpful framework for everybody else to think about and use when all you folks are analyzing some of the unusual and complicated access questions that we get in the highway planning world. So, overview of this presentation, I provided it here. I want to identify some of our sources of access management, establish a framework for how we use those to analyze the unique circumstances that pop up, and then try to give you guys an analytical framework, as I said before, to figure out what do I need to look at, what do I need to analyze, what information do I need to make the best decision I can when determining the various types of access questions that come up, whether it's planning through a project or granting permits or maintaining highways. So I thought about it as a toolkit. We've got 4 main tools that we're going to talk about, but disclaimer ahead of time, my tool analogies aren't perfect, so if you don't like them, I'm sorry, they're as best I could do. So this one I think is the best. I think the hammer is the most appropriate one, and that's for statutory access control. A lot of states have, almost all states have some sort of statutory access control. Wisconsin, for example, has access control for laying out interstates, freeways, expressways, as well as limited access highways, which we call a controlled access highway, and that's under our state statute 8425. These are the strongest expressions of police power, which we'll talk about a little bit more later. But it's the legislature saying, DOT, here's a way that you can manage access, essentially no questions asked for the betterment of the highways, as long as you exercise it in a reasonable fashion and in accordance with the rules that we've laid out for you. For example, Wisconsin has a pretty strong state statute in the form of 8425, which once we've laid out the limits of a controlled access highway as an 8425 highway, you essentially have lost any legal rights to ask for a driveway at any specific location, appeal any of the decisions of the department, or otherwise dispute how we manage your access. Case law on 8425 effectively states that the only question that the DOT needs to asks itself if we're eliminating your access for 8425 highway is, do you have alternative access in some form or fashion? Are you essentially not landlocked? That's our only question that we need to ask in those circumstances. You know, as I put up here, there's other types of statutes that legislatures have out there that allow you to control access. Like I said, freeways, otherwise, you know, placing setbacks on highways, in the form of subdivision or plat approval. Those are some of the other statutory authorities that state DOTs might have. Administrative code, I'm sure all of you are very familiar with that. My research indicated at least 40 of 50 states have some sort of administrative code that regulates location of driveways, sighting distances, uses, things like that. Otherwise, they have some reference to allowance for the state DOTs to develop manuals and standards for access permitting. So, one of the benefits of using access standards, as I'm sure everybody here is familiar with, is it allows you to develop standards for the design of those access points, what types of uses are okay, the number of accesses, and the location of those accesses. And you use that in the form of your permitting authority to manage those accesses to your highways. Eminent domain, I use the term eminent domain because that's most often how we acquire access rights in Wisconsin. We rarely do it through negotiated purchases absent a project. And I called this the saw because really the way that it's used is to either cut off access. We need to do something to get your access off of our highway because we're developing it in a way that this is going to be a problem for us. So we're just going to buy it. And we're either going to say you have access off of another road, or we're just going to say you have access at this point, or some point that we designate as safe. So really we're cutting off your access through the use of a real estate acquisition. Otherwise, we can also do it potentially through, as I mentioned before, some of our permitting authorities such as setback subdivision approvals, things like that. At least in Wisconsin we have that authority. The downside to the use of eminent domain or real estate controls is, and the upside in some cases as well though, is that they're permanent. Until you do another real estate transaction, that's how the access is going to be. So you'd really lose a lot of flexibility when you have real estate controls on a property, whereas if you have like a permit, then if circumstances change, the highway use changes, maybe the use of the property changes, you can simply issue a new permit, update that permit, amend that permit. With a real estate restriction, generally speaking, you're going to have to do a new real estate transaction, and those can be fairly complicated and costly and time-consuming and controversial. And then finally, police power is the other major category that and tool that we have in our toolkit to control access on state highways. I call these the pliers because in my mind, it allows you to manipulate access. The best example of police power is that you are moving a highway off previous alignment. That's the ultimate police power. You're saying the highway is moving from location A to location B, and that's inherent in the state's authority to do that as the regulator of the highways. As you can see up there, I have Nichols distinguishes police power from eminent domain in the following way. Eminent domain is the taking of property, whereas police power is the regulation of property to prevent the use of property in a manner that is detrimental to the public interest. It's the power to legislate on behalf of the public and create regulations reasonably adapted for the purposes needed and not creating any arbitrary discrimination between different classes. And I think that's one of the big keys when you're exercising your police power authority in a lot of respects, is that you exercise it in a way that is not arbitrary, because that's the big trip that you could potentially encounter if you're exercising your police power authority, is if you act in ways that are inconsistent, that's where courts are going to give you a hard time. If you're acting in a way that is completely out of character with how your department's done things in the past, or is different than a set of property owners in a certain corridor, that's going to be an issue where you really have some problems. But the police power is a really good tool because it generally is not accompanied by any compensation, right? If we're exercising our police power authority, unless there's a regulatory taking in the sense that we take away all or essentially all of the value of the property, there's no compensation for that action. Now, the police power is manifested in some of the other things we talked about before. It's manifested in the statutes, it's manifested in some of the permitting authorities that we have, and it's also manifested in how we do our projects. I mean, all the projects that state DOTs are laying out are pursuant to some delegated police power authority from the state. So this is the meat of the presentation now that we've got the foundation, is how do we use our toolkit when we get unique and unusual questions thrown our way to determine what's the best course of action. How do we manage this situation, whether it's moving a driveway or analyzing an eminent domain question, compensation question. How do we do that? So kind of the best way I thought to look at it was in sort of a hierarchy of importance. First, determine whether the abutting highway is controlled. If you have, for example, in Wisconsin, 8425 highway, you have all kinds of authority to manage those access points, and it's a pretty high authority. So you can do significant things with that. You have to be judicious in how you exercise that authority, but that's a pretty strong control. All the other questions here are going to be subject to that initial controlling authority. If yes, identify the type of control. That's important. Assess whether the property already had some sort of other control on it, whether it's a permit, a real estate interest held by the DOT, a setback on the property, some sort of existing real estate restriction on the property that would dictate how they can use their access. Analyze the permit terms, analyze the title work, determine what are those conditions of control, because once you have a handle on that, it may foreclose or open a lot of options right off the bat. You know what sandbox you're playing in. Determine whether your desired action is an exercise of recognized police power. In other words, determine whether you have a significant stake, the public action that you're taking is a significant enough stake to assert that police power authority, or do you need to use your eminent domain authority just because this is preferable, but not necessarily something that meets, whether it's spacing issues, safety issues. It may not rise to that level of something that would be sufficiently in the public interest to say, oh, it's automatically police power authority. It may need to be something where you just have to buy it because it's preferable for the function of the road. If you're exercising the police power, is it reasonable and justified by the needs of the public? Again, that's going to be, what are your manual standards? What is the basis for what you're doing? What type of project are you laying out? What are the private property interests that are at stake? Just balancing all of those things. How to use the tools. I got some real-world examples that I've dealt with over the years. I've modified some of the facts in some of my examples just to illustrate some bigger points here, but I think it'll be helpful to go through these quickly. So this is an interesting one. This isn't a freeway, so we've got freeway controls on here in Wisconsin. That means that once we designate this as a freeway, nobody has a right of direct access to that property. We've either bought their access so that they can no longer access that highway, or we've put them on a side road, frontage road, whatever the case may be. So here we're doing a little improvement project here on this overpass, and we're buying some right-of-way here. The property owner has a monument over here on their property that they've been accessing by driving from one area of the property over here along DOT right-of-way to the monument. Well, so the first thing that I would do in this situation is, okay, we've got a freeway. This is access control. They don't have any right of access to go from their property onto this highway and go down here to this monument. They don't have an interest in that. That's subject to the regulation of the state. But okay, we're buying some property here. Well, does that change things? The fact that we're buying an area where they're claiming they have access, does that change things? In this situation, no, because our acquisition isn't affecting their access at all. The third thing that I look at here too is that this is external circuity. This is not a question of internal circuity because they're using existing DOT highways to access another part of their property. Our acquisition is not affecting something where they travel along their property to get to one other side of their property. They always use the public right-of-way. So that's one way to analyze a problem, is to use that framework to kind of go through those questions and say, okay, we don't have a problem here. This is not something that is a DOT hurdle to DOT doing this project or something that we would have to pay for. Here's another example. This one's police power. This is kind of our classic example in Wisconsin for those of you who might not be familiar with it. It's the 118th Street case. But in the before condition, this property owner here had an access up here on this road. This is a local road. There's a freeway improvement coming through here. As part of a project in this area, this whole road moved away. This property owner said, hey, wait a second, I had access onto that road. You got to pay me for that. Okay, do we? That's the question, right? So, well, what did we do here? Okay, there's no controls on this road. This was a local road, so DOT didn't have any controls on it. So I've got rid of the statutory questions there. But what happened? We moved the highway. As I said before, that's police power. And in Wisconsin, at least, and many other states in my research indicated as well, if you're exercising the police power authority, there's no compensation unless you've taken all or substantially all of the value of the property. Now, they had a small real estate transaction down here, but that was unrelated to the issue, which was this access up here. So in this case, there was no compensation because we were exercising police power authority, and we exercised it appropriately because they had reasonable alternative access. So there was no compensation in that case. Now, if any of you were here for the presentation by Hans Zietlow of Quick Trip, this was one of his properties that I dealt with, and they weren't very happy about what we were doing on this one, and we come to find out later why, and he explained it in his presentation as well. But I thought this was a really good example of using all these tools as well. Now, we've got a freeway down here, and we're improving the interchange right here. And as part of that, we want to control further up this side road. Now, we didn't designate any of the area up here as part of our freeway improvement project. So now we've lost one of our tools. I can't say, well, this is part of the freeway improvement project, and so as long as you have alternative access, we don't have to worry about compensating you in eminent domain. I lost that tool. So that one's out the window. The next question is, okay, what are we doing here? How are we getting rid of this access? Was there a permit, or are we buying it with a real estate transaction? We were buying it. We had access controls through real estate all the way up here. Okay, now the question becomes an appraisal question. Okay, they need to have access in the remainder. Is their access going to be reasonable, number one? And number two, am I going to have to pay for it? So if we move on to the after example, this is what we were doing to their property. We were making the car traffic and the truck traffic use this same entrance for entry if you're making a right-hand turn in here, putting a median in here, and then putting a service road back here to provide for more appropriate internal circulation. Now you look at this on its face and you say, okay, well, it looks like everybody can do the things they need to do. Trucks can pull in there into this. Now it looks like they pull in here and park here, and that seems to be okay, and what's the problem? Well, come to find out, and as Hans will tell you, the problem is that the way that truck drivers use these things is that they will line up to get into these pumps, fill with gas, and then pull through, as you can see here, and then go do their business in here. Now, some might park up here for a more permanent stay, but generally speaking, that's how they do their business. And if they can't do that because the internal circuity has changed, that's going to be a big damage. So now we know what we're working with. We've got the facts on the ground to analyze that problem and figure out, okay, I've got a taking here. I'm looking at compensation. How much is it going to be? And then we can go through and analyze that. So so summary of this one, I've lost my access control down here that might have negated some compensation. I've got a taking here, so now I'm looking at eminent domain issues and compensation issues. And I've got the standard sort of access management questions, reasonable access, like Pat Hawley talked about an hour or so ago. What kind of access is in the after? So that's how we work through a problem like that. And this final one that I've got here, I think, is a really fun one that we can kind of work through. So the actual situation here, and this is up in northern Wisconsin, there's a lake here. You can't see it, but there's a lake here. So this is an isthmus that comes through. This is a state highway, fairly high volume highway in certain respects, in certain times of the year because it's a tourist area. Other times, not very high volume. You've got two properties here. There's the property line there. They've got an easement, and this is an 8425 designated highway. So we've got an access control map that puts one driveway here and one driveway here. So we've got our strongest authorities on this. This road, or this driveway right here, is a problem. We're coming through with a project, and we want to figure out what to do with that. I mean, it doesn't meet a lot of our standards. Can we eliminate it, right? Can we force him to use this easement? Now, with the 8425 controls on there, yeah, as long as there's alternative access, we could probably force these property owners to use this easement and just access the highway up here. Not a great solution for them. They wouldn't really appreciate that, I'm sure, but we have that ability. Okay, that's potentially easy solution in that case because of the nature of the controls that we have on it. What if we didn't have those controls? What if we're coming through with a project and say, we want to get rid of this access, then what? Can we get rid of it through our permitting authority? Well, now we're talking about balancing our administrative code. In Wisconsin, it's our administrative code standards versus the right to have the minimum number of driveways reasonably necessary to serve your property. Now, it might not meet all our standards, but to what degree? I'm going to go through with our access people and challenge them on all of those questions and say, okay, do you have crash data here? Well, what if there aren't any crashes? You know, is that a consideration? Well, how, you know, it doesn't meet site distances, but is that typical in this area? You know, what kind of case are we going to be able to build when we go before an administrative law judge and say, we want to revoke this access and force these property owners to share this easement? Is that reasonable? Is that a good use of our authority and our police power authority? I've got to build that case so that we can win that. And so those are the types of questions I'm going to ask. You know, I thought another interesting potential example on this one could be, what if this easement wasn't here? What if you've got a really dangerous driveway here and there's no easement and this is all owned by one property owner and he wants to sell this off? Now he comes to DOT and asks for a driveway for his separate property, right? What do we say to him? Well, if we don't have any access controls like we have on this highway, and it's not 8425 as we call it in Wisconsin, well, now we're getting back into the standards, and now we're doing that balancing act again. We're saying, okay, it doesn't meet any of our standards. Is that enough to say that we can't grant a permit? And, you know, that's where you build that case, but you've also got to think about, again, you're balancing that against, you know, the interest. But what if there's setback issues in there? You know, he's against water there. What if there's local regulations that prevent him from subdividing that? I mean, you probably have all dealt with these. You've got tough questions about exercising the authority of the highway in the interest of the traveling public versus the right of people to develop their property. These aren't always easy questions. So the examples I have, I think we've got a few times questions. This was the other part of that was interesting. To get the right site distance, they would have to cut down all of these trees to get the right site distance for that property. Now, you tell a property owner that and see how they react, right? I mean, this is their vacation home. They're not going to be happy about that response, right? We'll give you a driveway permit. Just cut down all of your trees. So that's all I have for today. But if there's questions,